Well, if you're joining us, is that proceedings on the proposed removal from office by the impeachment governor of Kericho County, Governor of Kericho County, Mutahi, has commenced at the floor of the Senate. Earlier on, we saw the reading of the charges done by the Senate, with the governor taking the stand, with the governor taking the stand, charges as read by the charges as read by the clerk. Then stand before this particular break, that before this particular break, that is sort of a break for the members to be able to familiarize themselves that have been presented before them by the legal team of a legal team of the senior council, that is and for the senators to be able to allow me to hand you over back to the
Thank you, Mr. Speaker. Mr. Speaker, rising to request for and probably a bit of guidance, clarity, and probably Mr. Speaker. This is a time-bound process. This is a time-bound process. Thank you. Thank you, Mr. Speaker. Thank you, Mr. Speaker. Even this one is dead. Even this one is dead.
Honorable members, allow time for the system to be fixed. Time for the system to be fixed. So that we can proceed. So that we can proceed. Just a few minutes. Just a few minutes.
Well, this is the Senate proceedings on this Senate proceedings on this with regards to the proposed removal from office by impeachment. Governor of Kericho County, Governor of Kericho County, that is Dr. Eric Kipkoech Mutahi. The County Assembly, on of October resolved to have the governor removed from office the governor removed from office and made their resolution known to the Senate. The Senate opted to undertake or consider this by way of plenary. by way of plenary, and the process has begun this morning. This morning, 10 a.m. At what we are seeing now is that the House, what we are seeing now is that the House is going through or still receiving some documents presented by the governor's team from the side. Governor's earlier on, the charges were read to the governor, which he pleaded not guilty. He pleaded to all of them, and then we saw them, and then we saw the team from the governor's side, led by Senior Counsel Keegan, also to make their statements, opening statements. But there are documents that the senators had indicated that were not in their possession. And the governor's side indicated that the documents are available and can be shared and can be shared. So that is what we have just seen. So that is what we have just seen. For the members to be able to go through and for the members to familiarize themselves with the contents of those documents, as the presentations continue. Remember, both parties inside the chambers. That is the party inside the chambers over the side of the governor, over the side of the legal team, as well as the side of his legal team, as well as the county assembly of Kericho County, of course, with of Kericho County legal team as well, legal team as well. And the process for consideration has already begun. As you can see, members consulting in law as well as also going through the documents that have been shared by the governor's side. The charges that are facing the governor is seated inside the chambers. Of course, throughout this whole process, throughout this whole process, will be present inside the chambers until the time of voting, when the time of voting, when the Senate to make its decision. Throughout all the presentations, both parties will be there. Remember, at this point, both parties will be there. Remember, at this point, both parties will be required to give out their evidence, whether it's witnesses, whether it's witnesses whom whether it is a video or whether it is a video or audio clips that they will be wishing to play.
Senator Fuller, Senator Sek, Senator Alan Chesang, Now, as we are struggling to restore the system, we are going to use the two microphones. We are going to use the two microphones. That are placed on the dispatch. Any senator willing to say anything will have to walk to say anything will have to walk to proceed. Dispatch to proceed. Say whatever they want to state. Say whatever so that we save on time. We cannot wait until the system until the system. Now, I want to believe that all honorable senators have been given the correct bundles. Is that the position, honorable senators? Is that the position, honorable senators? We do have the correct bundles. As you may have noticed, we have lost considerable amount of time. As Senator Boni has this is a time-bound process. This is a time-bound process. According to our standing orders, we are supposed to give half an hour. Give only to preliminary objections. We have gone beyond that. So I seek your indulgence. So that we move with speed. I will allow the counsel for the governor to proceed and conclude raising preliminary objection, and thereafter I will allow the county assembly team to respond. The plenary thereafter will have an opportunity to respond. Or make any intervention. Or rather debate. the preliminary objections as raised by both sides. Counsel for you had done the governor. You had done 10 minutes before the confusion on documentation. You have 20 minutes to conclude. And therefore, you have 20 minutes
Thank
to
you,
conclude.
Mr. Speaker, sir. Thank you, Mr. Speaker, sir. Thank you, may I first of all, senators, for the accommodation. Honorable senators, for the accommodation. I appreciate the point made by Honorable Sifuna that I fell below what they have come to expect. I fell below what they have come to expect of me. My profuse apologies. Now, the second order I was referring to, the second order I was referring to is in volume 122, and the effect of that order and the effect that it stopped the county assembly from making any resolution on the impeachment and making any resolution on the impeachment. They proceeded to engage in discussing it and engage in discussing it. Attendant to which it was forwarded to the honorable. It was forwarded to the honorable. It is our position that having acted in violation of the court order, having acted in violation of the court order, impeachment motion before you, impeachment motion within the meaning of the rule of law, within the meaning of the rule of law, and the relevant part of that order is order number 5. That order is order number 5. Was told that pending in the Senate was told the motion dated 1st of October, interim conservatory orders of October, interim conservatory orders jointly and severally suspending, jointly and severally the debating, considering or acting upon the notice, considering or acting upon the notice September 2024 and motion September 2024 and motion moved on 24 removal of the applicant for the removal of the applicant. Those are my first two preliminary objections. Those are my first two preliminary objections. Move on to the Mr. Speaker, sir, I would like to move on to the third preliminary objection. And the third preliminary objection is to the effect this motion before you does not meet the two-thirds threshold. Meet the two-thirds threshold. Now, Mr. Speaker, sir, the absolute facts upon which I wish to raise that preliminary objection as number one, Mr. Speaker, sir, I know amount of time. The first one, honorable senators, the first one is that Kericho County has 47. Is that Kericho County has 47 assembly members of county assembly. And
honorable members, can we have silence? Can we have silence, please?
Thank you, Mr. Speaker, sir. Thank you, Mr. Speaker, County has 47 members of county assembly, 30 elected and 17 30 elected and 17 nominated. Sir, all of them are Mr. Speaker, sir, all of them are functional in the sense that there is no vacancy situation where there is any vacancy that is not. Now, Section 33 of the County Government Act requires that an impeachment motion must two-thirds, and I put emphasis on the use of the word at least. And I put emphasis on the use of the word at least. For County Assembly of Kericho, for County Assembly of Kericho, 47 MCS, constituted of 47 MCS, that is achieved when the vote comes to 31.3. Comes to 31.3. To 31.3. Thank you. I'm being asked to change the microphone. Thank you. I'm being asked to change the microphones. Now, in the case before you, Mr. Speaker, sir, and honorable senators, the impeachment was passed with a vote of 31 votes. And it is our argument that 31 is not the same as 31.3. Combine the use of the word at least in Section 33 of the County Governments Act, the threshold being 31.3. The threshold being 31.3. When you scale down to 31, then you have immediately fallen short of the requirement of the statute, requiring at least two-thirds. 16 of the county assembly members, as per the Hansard which you have been afraid, Mr. Speaker, sir, and that Hansard is in volume 1, and that Hansard is in volume 1, page 82 to page 161. Page 82 to 161 contains the Hansard proceedings of that day. And the significant pages would be page 160 to 160 to 161, at which the Speaker then, the Speaker of the County Assembly then wrestled with the question whether that one amounts to two-thirds. He then goes on to say at page 160 that my position is fathomed by the fact that we have customarily, and by practice since the inception of the devolution taken one third of the members of this assembly that is 16, meaning the balance of the members being meaning the balance of the members being 2/3 is equivalent to honorable senators. I will show that honorable senators. I will show that the Speaker of the County Assembly the Speaker of the County Assembly very specifically wrong and very specifically wrong. And now, Mr. Speaker, sir, having said then, now, Mr. Speaker, sir, having said it is only 31 out of 47 who voted. It is only 31 out of 47 who voted.
Senator Manzo and Senator Kajuan, let's hear the council in silence. Let's hear the council in silence so that we.
With that in place, Mr. Speaker, sir, with that in place, Mr. Speaker, sir, if the honourable senators, if the honourable senators, for one moment, the provisions of Section 33, for one moment, the provisions of Section 33 of the county government act, if they were to draw a line at the point at draw a line at the point at which you would be drawing a line at the point at which you are achieving at the point at which you are achieving 31.3. If you come to that 1.2 or 31.1 or 31, you have fallen short of the provisions of Section 33 of the provisions of Section 33, saying it is our argument that this motion could only have succeeded that this motion could only have succeeded if it had 31.3. When it scaled down to 31, it immediately fell short of the provisions of Section 31 of Section 33 of the County Governments Act, 33 of the County Governments Act, and number 74. Standing order number 74. Mr. Speaker, sir, I would also want to. Mr. Speaker, sir, I would also want to invite the attention of this. Invite the attention of this to the events that have happened previously in the County Assembly of Kericho. On the 20th of September 2022, as can be seen in Volume 1, as can be seen in Volume 1, at page 34 to page 39, 34 to page 39, 34 to page 45. And the impeachment motion was taken out against the previous sitting governor, and more particularly at page more particularly at page 34, may I make a correction, Mr. Speaker, sir, honorable senators? The impeachment is at page 34. The impeachment is at page 34 to page 36. 34 to 36. It will be noted that proceedings, those impeachment proceedings of the honorable previous governor that took place on the 14th, that took May 2024. You will see 2024. You will see 14th May 2014, 10 years ago. 14th May 2014, 10 years ago. The honorable speaker then. The honorable speaker then, I wish to notify the members that there is a constitutional requirement that for this motion to pass there should be 2/3 of the members present in the House. So the members present in the House. Before the motion is moved, kindly confirm that we have 32 members. It is clear 10 years ago that the Kericho County in its mind Assembly that any impeachment or the threshold of 2/3 requires 32 out of 47. I would like to cite another example that happened 2 years ago, and that is at page 37, and that is at page 37. And I have particular reference to what is contained at page at page 42 of that bundle. At page 42 of that bundle, Mr. Speaker, and honorable senators, Mr. Speaker, this was the election of a speaker. This was the election of a speaker. This specific speaker, Mr. Speaker. In that discussion also, whether he could take office or not, it was discussed to this effect when it was being presided by the clerk. The clerk said, thank you very much, honorable members. Before we proceed to count the votes, I have very important message to communicate. Please note that the person person shall not be elected as a Speaker of the County Assembly unless supported by two-thirds of the members of the County Assembly. Two-thirds of 47, we need a two-thirds of 47 or we need 32 votes, and that if we don't get that, then we'll have to repeat the elections. If we don't get that, then we'll have to repeat the elections. I would like also to play the audio upon which the specific speaker, who presided over these proceedings, was elected and which reflects that. I request your IT department to play video number 2. That's not video number 2. That's not video number 2. Is with the speaker. Is with the speaker. Video number 2. I don't know whether they are playing video number 2 of. Yeah, it is a video where the clerk is presiding over the process of elections. And it is the video submitted by the governor. It is the video submitted by the governor as opposed to the video submitted. Video number 2, please. County Assembly. Video number 2, please. Mr. Speaker, sir, can I proceed and then we come back to the video when it's found? And then we come back to the video when it's found, so that we save on time. Yes, Mr. Speaker, sir. Yes, Mr. Speaker, sir. I'm sorry, Mr. Speaker, I didn't hear you. I'm sorry, Mr. Speaker, I didn't hear you. Yes, he's gone. Yes, he's gone. He's just left. He's just left, Mr. Speaker, sir. He's just left, Mr. Speaker, sir. Can I argue the other points and then I come back? Can I argue the other points and then I come back? Yes, thank you very much, Mr. Speaker. Apart from relying on those two instances, the 2014 criteria by Kericho County government, determining that the two-thirds is the required threshold of the impeachment of the predecessors of the impeachment of Honorable Dr. Eric Mutahi. Apart from that, and apart from the criteria also applied when the current criteria also applied when the current speaker of this motion also said that 32 MCS was also decided that 32 MCS required to vote in support to amount to. I wish to make reference also, Mr. Speaker, I wish to make reference to the events of the National Assembly. To the events of the National Assembly. Mr. Speaker, sir, the Honorable Mr. Moses Watengula, in a ruling made on 1st of October, and a ruling made on 1st of October, and which I pray, Mr. Speaker, it was in public domain, and it was in public domain, the issues that had been raised by a number of MPs, being whether two-thirds is mastered by 116 MPs by 116 MPs, or and the very relevant bit of that situation, Mr. Speaker, Mr. Speaker, is that in the National Assembly, is that in the National Assembly of the total number of members of the National Assembly, being of the National Assembly, came to 116.33. And so we find similarity with our case being, we find similarity with our case being, the same as what happened in the National Assembly being
and the Speaker was very categorical, saying
the Speaker was
that
very
then
categorical,
the
saying
two-thirds for purposes
of the one-third
for
to approve
purposes
the impeachment,
of the one-third to approve
motion
the
for the
impeachment,
deputy
motion
for the
would
deputy
require
president
117, would
being
require
that you move
117
a step further. You don't
being
scale
that you
down to
move a
116,
step further.
you
You
scale
don't
up
scale
to
down to
116,
116.
and
Mr. Speaker,
Mr.
that ruling by Mr. Speaker, that ruling by Honorable
Watengula is dated 1st of October 2024,
is dated 1st of October 2024,
and we pray, Mr. Speaker and Honorable Senators,
Mr. Speaker
and Honorable
the
Senators,
criteria used to elect the Speaker,
the criteria used to impeach Honorable Chepkoin, to consider the impeachment of the deputy president. I know it hasn't happened. Of the deputy president, I know it hasn't happened. The criteria used to impeach the impeachment of the deputy president, the impeachment of the National Assembly, used to one formula being that you move a step further, because you cannot have a fraction of a person, because you cannot have a fraction of a person. That criteria in the case of Eric Mutahi, in the case of Eric Mutahi, just because it is Eric Mutahi. It is our argument that that would be, it is our argument that that would be discriminatory. The last incident that I wish to cite is the events of Nyamira County government. County government, there are 34 members of county assembly. 34 members of county assembly. And out of the 34 members of the Nyamira County Assembly constituted of Nyamira County Assembly constituted of 15 nominated and 20 elected, one-third was found to be 11.3. We again find 11.3. We again find the same in the case of Nyamira. And in that case of Nyamira, and in that case, County Assembly of Nyamira adopted the approach that you scale up to 23 people. As opposed to, 11 people as opposed to, 11 people as opposed to, coming back to 10 people. Then, Mr. Speaker, for that reason, I insist that it would be discriminatory to deem the motion that has been brought to this assembly, the motion that has been brought to this assembly, to the extent to which being competent, to the extent to which it fell clearly short of 31.3. Mr. Speaker, I am aware that my colleagues to make the argument that this is an issue, that this is an issue not quite squarely rest on your hands under the provision under the provision. It is my argument, Mr. Speaker, sir, that it is my argument, Mr. Speaker, sir, that it is your hands, Mr. Speaker, sir. Within the said Rule 30, the said Rule 30, Mr. Speaker, sir, where on a particular question, where on a particular question, not limited to the question of including but not limited to the question of evidence, relevance, materiality, or relevance, competency, or any question consequential or incidental thereto, where no provision has been made in the standing orders, where no provision has been made in the standing orders, the Speaker of the Senate shall rule, the Speaker of the Senate shall rule. Mr. Speaker, sir, it is my argument, Mr. Speaker, sir, it is my argument that this is an issue that falls. It is my argument, Mr. Speaker, sir, it is my argument, Mr. Speaker, sir, 14 and 30 was being enacted, this Rule 14 and 30 was being enacted, a situation like this, must have where you need to make a decision, where you need to make a decision as to the competence of this impeachment motion before the senators, this impeachment motion before the senators, that is consequential as to whether we should go on or not, that is consequential as to whether we should go on or not, related aspects of the competence of the competence of impeachment motion. Mr. Speaker, sir, it is my argument, Mr. Speaker, sir, it is my argument that the Senate, in a certain sense, is on trial. In a certain sense, is on trial as to whether it will maintain the requirements of Section 33, the requirements of Section 33 on the at least and the attendant aspect of the rule of law, flowing from whether or not the observance of that requirement of Mr. Speaker, sir, I will request Mr. Speaker, sir, I will request for just 7 minutes to make reference to a decision made by Justice Manani, to a decision made by Justice Manani, and which is in volume 1, page 60 to page 70, page 60 to page 70. And in that case, Mr. Speaker, sir, and in that case, Mr. Speaker, sir, said that learned judge said that where the requiring a certain threshold, in that case, requiring a certain threshold, in that case, it was one proceeding that fell short of the one proceeding that fell short of the paragraph 90 of 90 paragraph 90 of then 90 onwards. Page, then I said it is page 60 to page. I said it is page 87, and in more particular, and in paragraph 90, which is at page paragraph 90, which is at page 71. At page 71.
at page 71, where the judge says it is perhaps also necessary to point out that standing order 68 subsection 8 standing order 68 subsection 8 when directing that a committee be set up and should comprise one-third, and then goes on and should comprise one-third, and then amount to one-third. If they do not amount to one-third, then it doesn't meet the threshold. It is a very significant point that the learned speaker, or rather the speaker of the county assembly of Kericho, and you will find his reasoning at page 161 with reference to that case of Michael Ngaduda versus County Assembly of Tana River, and it goes on to say that you round off. Goes on to say that you round off. And when you are rounding off, you can never rounding off to fall below the line. You can never round off below the line. You can never round off to fall to less than 1/3. And if you are to do that, then you would be acting in contravention of the law. Mr. Speaker, sir, with that said, I would pray now to play that video. And request Mr. Speaker, sir, for 5 minutes. Mr. Speaker, sir, for my colleague Mr. Tonen, just to on the preliminary objection. Kindly, Mr. Speaker, on the preliminary objection. Kindly, Mr. Speaker, sir.
Before we proceed to count the very important message. Honorable members, please note that honorable members, a person shall not be elected unless supported by the votes of two-thirds of the members of two-thirds of all the members. Two-thirds for us to be 7. Two-thirds for us to be needed to have 32. We needed to have 32 votes plus 32 plus. Now, the candidate who receives the highest number of votes, and the candidate who in the ballot receives the next highest. The ballot receives the next highest. We don't get the 32. The only candidates that we shall go to round 2. Now, when we go to round 2, they tie. We shall go to round 3. We shall go unless to round 3 is broken. Unless that's when we shall declare. Is when we shall declare. Thank you. Now, thank you. Now, Sergeant Adams, please.
I think that's okay, Mr. Speaker.
Is the number of votes. Is the number of votes. If there are 47.
Mr. Speaker, sir, that shows the election of the Speaker, who made the arguments that I've just referred to, in which he says, because it's that 123, you scale it down, you round it off to the next. You scale it down, you round it off to the next. Yes, thank you, Mr. Speaker, sir. Mr. Speaker, thank you, Mr. Speaker, sir. It is my submission, Mr. Speaker, sir. It is my submission, Mr. Speaker, sir, that there are 2 issues honorable Senate need to address. And this honorable Senate need to address is what is the meaning of at least what is the meaning of Section 33 of County Government Section 33 what is the meaning government and when you apply the calculation in respect to Kericho, does it mean 31.3 and above, does it mean 31.3 and above, 31? So the first issue is what is the meaning. So the first issue is what is the meaning of at least in 33 of the County Government Act, 33 of the County Government Act, together with Standing Order number 74, Assembly Standing Order number 2, Assembly Standing Order. The second question, Mr. Speaker, sir, the second question, Mr. Speaker, sir, how do you treat a fraction? How do you treat where it relates to human beings? Where it relates to human beings? Because it's 0.3, you dismiss it and scale it down to 31, you dismiss it and scale it down to 31, or even 0.3. And this is very significant, Mr. Speaker, sir. When you look at the situation of this proceedings, when you look at the situation of these proceedings, that being Mr. Speaker, sir, 47 MCAs there were 47 MCAs saying we are not attending. Number 1, number 2, they are not attending. Number 1, number 2, they say we do not support the motion.
31
The
were
other
present and
than,
they supported the motion.
31 were
Mr.
present and they
Speaker,
supported the motion.
Following the
Mr.
tradition
Speaker,
of both the Senate and the
following the
National
tradition
Assembly,
of both the
it
Senate
is
and the
always the
National
case
Assembly
that
it
when
is always the case
members have
that
not
when
voted in favor,
members
it
have
is
not
deemed
voted
that
in
that
favor,
vote was not
it is
in favor.
deemed that that
And so the
vote was
16
not
must
in
be
favor.
treated
And
as
so the
having
16 must
opposed
be
the
treated
motion.
as
It
having
cannot be
opposed the
given
motion.
conjecture
It cannot
the
be
23
given
could exist in
conjecture
the
that
16,
the
Mr. Speaker,
23
sir.
could exist
It
in
is
the
my
16,
argument,
Mr.
therefore, then,
Speaker,
Mr.
sir.
Speaker,
It is
sir,
my argument,
that
therefore, then,
clearly
Mr.
it
Speaker,
didn't meet
sir,
that
the
clearly
threshold.
it didn't meet
And
the,
Mr. Speaker,
the
sir,
threshold.
I wish to
and
say
Mr. Speaker, sir,
that
I wish to
considering
say
that
the president from your colleague from the National Assembly,
your colleague from the National Assembly,
we pray
that for purposes of consistency, Mr. Speaker,
for purposes of consistency,
unless you have a very
Mr.
strong
Speaker,
reason to disagree with him,
you adopt the reasoning he has applied,
you adopt the reasoning he has applied
and clarity
for
of law,
consistency
and
and clarity,
Mr. Speaker,
of law,
that if the
and
criteria
secondly,
is
Mr.
used
Speaker,
differently,
that if the
from
criteria is
Nyamira,
used
from
differently,
National
from
Assembly,
Nyamira,
from the
from
election of the
National
Speaker,
Assembly,
from the
election of the
impeachment
Speaker,
of Honorable
from
Jim Point,
the
impeachment of Honorable Jim
discrimination.
Point, then
Mr. Speaker, sir, I had requested for just a little latitude. I had requested for just a little latitude. Could you allow him just 2 minutes, Mr. Speaker? Could you allow him just 2 minutes, Mr. Speaker, sir? Kindly.
Council, your time is up because you kept repeating yourself. Time is up because you kept repeating yourself in different in different form. So you may want to rest your maybe I need to ask you.
Yes, Mr.
Maybe
Speaker.
I need to ask you.
Yes, Mr. Speaker, sir.
In response to the preliminary objection raised by no real objection, but a matter, no real objection, but a matter from the county assembly. You have no problem. You have no problem. The 13th of October 2024 be admitted.
I confirm, Mr. Speaker, sir, that I have no objection. Mr. Speaker,
and
sir,
we have
that I have no objection,
and subject to the Senate
and subject to the Senate, and we were agreed that they accept our that they accept our documents properly paginated, documents properly paginated, and we will have no objection to the
application.
We strongly object, Mr. Speaker, sir. We strongly object, Mr. Speaker, sir. But as I said, have this restraint of the order. We have this restraint of the order. We want to be very measured, not to seem to be very measured, violating the order that we already violating the order that but we already have in our
county assembly. Council, you may now proceed the county assembly. You may now proceed to raised by the respond to the PO as raised by the Council.
Thank you, Mr. Speaker, sir. Honorable Senators, for the opportunity. Honorable Senators, for the preliminary objections. The two preliminary objections are opposed by the County Assembly. The County Assembly. Effect, Mr. Speaker, sir, to that effect, Mr. Speaker, sir, asking you to allow a copy of the supplied to signing affidavit to be supplied to reference the same. We will it is already with the Secretariat. It is already with the Secretariat. 8. And if that can happen, Mr. Speaker, sir, with your permission, Mr. Speaker, sir, with your permission, I could proceed. The two preliminary objections.
Do you have that?
Preliminary objections.
Do you have that? Where is it contained? Where is
it is yet to be supplied, but it is with the Secretariat. Pending your, it is with the Secretariat, Mr. Speaker, pending your ruling, Mr. Speaker, sir. So we can have that. So we can have that done.
Which affidavit are you referring to?
Volume 8 of the Governor's, Volume 8 of the Governor's documents, of the County Assembly's documents.
Are you referring
Volume
to
8.
Are you referring to the 13th of October 2024?
Yes, indeed, Mr. Speaker, sir. Yes, indeed, Mr. Speaker, sir.
Is it contained in any of the? Is it contained in any of the standalone volumes?
It's a standalone volume. It's a standalone volume.
The volume 8
be made volume 8.
The volume 8 be made
volume 8.
It's a standalone volume.
Yes.
It's a standalone volume. Volume 8.
I can confirm it is with the Secretariat. I can confirm it is with the Secretariat, sir.
Just.
But I could proceed because I will not be making reference. Because I will not be making reference.
You may proceed.
Thank you, Mr.
Proceed, Council.
We object to the two POs on the ground that the very nature of a PO, Mr. Speaker, sir, the very nature of a PO, Mr. Speaker, sir, it has to be on a pure question of law. What counsel for the governor is inviting you to do at this juncture is to consider matters, matters of fact. That are disputed, it is settled matters of fact. That if an issue is contested, if an issue is contested, that can only be determined by way of evidence. When you look at the issue of existence, when you look at the issue of the court orders, or non-existence of the court orders, the county assembly has that line of argument, opposed that line of argument, evidence show that there were not evidence show that in there were not. The county assembly is arguing that the county assembly is arguing that either forged or manipulation, either forged the judiciary system of that judiciary system can only be tested if we bring a witness before you to be able to clarify on that issue by just submissions from the bar, by just submissions on the issue of. On the issue of whether the motion met the threshold, again, Mr. Speaker, sir, you will note that this is an issue that has been contested. This is an issue that has been contested. We will be producing evidence before you that the threshold was met. That how then, honorable senators, are you able to make a determination without listening to the evidence, without listening, looking at the materials, without that looking at the materials that we submit that are relying on? The only way to do that is to allow this matter to proceed, is to allow this matter to proceed on merit, then the validity of a certain fact, by validity of a certain fact, by examination in chief, and by questioning the witness in chief, and by questioning the witness, rather seeking to produce, or rather seeking particular evidences. Those particular evidences. Council has sought to rely on Rule 14 and 30, on Rule 14 and 30. Are your rules here to make an assertion that the decision on the two POs, the decision lies on the two POs. We beg to differ, Mr. Speaker, sir, on the following reasons. Mr. Speaker, sir, on the following reasons. Is that today the Senate sits. Is that today the Senate sits as a legislative house, not but a quasi-judicial house, but a quasi-judicial body. Any decision to be made. So any decision to be made in your capacity as a quasi-judicial body. So the question then is, who is sitting then to hear to this the matter of impeachment of the governor? Is it the speaker of the governor? Is it an individual? Is it the speaker, senator, or is it an individual? My submission is senator. It is the house that is seeking. It is the house that is seeking. Listen and give a determination on the question and give a determination impeachment the question of a governor. The impeachment and judicial authority is usually settling a dispute between two parties. There are two ways of making that determination. There are two ways of making that determination. One is on a technicality. One is on a preliminary basis. On a preliminary basis. Through hearing on the merits of the case and making a determination. Either making a determination. That decision can only come from the fact finder, from the judge, the fact finder, the jury. From the judge, the invitation that the speaker, in his capacity as a speaker can make in his capacity as a speaker can make that the decision of impeaching the governor or not impeaching the governor shall have been made alone by who does not have the speaker alone, the legal mandate, who does not have listen the legal mandate to an issue pertaining impeachment of a governor. On that basis, impeachment of a governor. I invite my learned friend Mr. Njenga, I invite to take you through the merits of the two objections. Thank you, Mr. Speaker, sir. Objections. Thank you, Mr. Speaker, sir.
Mr. Speaker, honourable members, Mr. Speaker, I'll go straight to the objections because of time. In addition to the argument made by my learned friend, I invite the honourable House. House to consider the import and purport of Rule 2 of the third schedule, the standing orders, which grants express jurisdiction to the Senate onto the Senate, A, to investigate the matter, and to investigate the matter, and to make determination of the allegations. It is our submission of the allegations that it is our submission to make that the determination, even on issues of law, the determination, even on issues of law, with the Senate remains, and it cannot be derogated by the application or by the interpretation of Rule 30. Or by the interpretation is clear. It's only Rule 30 is clear. It's only on admission competence, admission, and any other issue regarding evidence, and any other issue regarding evidence of the entire motion, not the competence of the entire motion. I proceed to respond on the question of the court orders that have been referred to by counsel that have been referred to by counsel. In making this response, I refer entirely to volume 8. That is the reply in affidavit. That is the reply in affidavit of the county assembly. Three quick points on that because of time, so that I can allow my colleague to refer to the last limb of the PO. First, the last limb of the PO. We refer you to paragraph 13 of that reply in affidavit that the validity of the orders, to the validity of the orders. The position is that those orders, position is that invalid. Those orders cannot be validated. Those orders cannot be validated provided for in the manner that is provided for. They cannot be validated from the judiciary CTS portal, from the judiciary CTS portal. Once you interrogate them against the practice directions of the High Court, the practice directions of the High Court and all courts, we have already supplied a copy of. We have already supplied a copy of. There is no means to verify there is no means to verify as a house indeed issued, whether those from the court indeed issued, and that will find from the particulars, and that will find the particulars. Interestingly, and we have a next a copy. Interestingly, and we have a next a copy. You will see orders as you will see as a next in our affidavit, as a next in our affidavit. You will see, for example, order. That the first order purportedly issued on the second, purportedly issued on the second, when the motion was being debated before the House, motion was being debated before the House. The parties to that order were the county assembly and the speaker of the county assembly and the speaker of the county assembly. It appears that the orders mutated a day after. It appears that the orders mutated a day after. Any reference to the procedure allowed and to the procedure allowed as provided for known to how you can amend a petition, as to how you can amend a motion before the House, so they amend a motion before the House. On the 3rd October, on the 3rd October, the Senate thereafter bring the Speaker of the Senate as and the Speaker of the Senate to the order as parties. How did they to the order mutate? How did they? How was Senate? How the Speaker? How was Senate? To the speaker, the same matter within a day, to the same matter within a day, it's without its participation. Participation. You will see that we have referred the screenshots. That the screenshots made the county assembly aware of this orders. Made the county assembly aware of this orders. The county assembly has taken the position. The county assembly has taken the position that it was not served, and that is paragraph 9 of the reply in affidavit. And that is paragraph 9 of the reply in affidavit that shall require strict proof. That shall require strict any affidavit of service. We have not been led to any affidavit of service by council whether those orders were served. It is strike law that an order that is strike law that is inoperative for all intents and purposes, including for all intents and purposes, including these proceedings. The orders appears to have been, and I'm referring to page 8 of this volume, and I'm referring to page 8 of this volume. On top, if you look at the times, they appear to have on top been circulated as early as 11:50 a.m. But when you go to the CTS portal, the application that yielded this order, the application that yielded 12:10 was filed. So we have a situation. So we have a situation where an order issued before even the application was filed for the Senate to consider. And we have escalated that matter as an issue of investigation before the JSC, before the Judicial Service Commission. We have a Judicial Service Commission. We have a letter, very comprehensive letter to reiterate its content before this House. Secondly, as I finish, without prejudice to those arguments, we have argued, and I want to make reference to paragraph 19. And I want to make reference to paragraph 19. We have the reply in affidavit on the import of this order to the Senate. Are they applicable to the Senate? Stopping the Senate from hearing, stopping the Senate from hearing proceedings. At this particular impeachment proceedings. We have referred the decision by the Supreme Court in the decision by the Supreme Court in the Justice Kariuki matter is annexed for the benefit of Senate. Is annexed. It's a decision that I had the pleasure of arguing. It's a decision that I had the pleasure of arguing in the Supreme Court, Senator with Professor Ojenda, who is seated here. Professor Ojenda, who is seated here. The Supreme Court was quite explicit. A court cannot restrain a constitutional organ a constitutional organ that is operating within its constitutional time-bound constitutional, and that I refer to the holding of the Supreme Court at paragraph 11, which will find 11 at page 20 of the volume. At page 20 of the volume. The import holding to this house is that the two orders referred to. The two orders referred to counsel for the county by counsel for the county cannot serve or cannot have the effect of stopping the proceedings before this house, the proceedings and before this house. Finally, as I sit down, Senate has already taken a position in that matter. Already taken a position. I will do nothing more than refer the Senate. I will do nothing more than refer the Senate to page 59. Page 59. This will be the last document I refer to. This will be the last document I refer to because of time. Yes, I'm actually yielding the floor to my colleague. Actually yielding the floor to my colleague. Is a position taken by the Senate. Is a position taken by the Senate in this matter. In this proceedings. And the Senate has said by way of a preliminary objection. By way of a preliminary objection. By that order. It has told the High Court by that order. It has told the High Court. We are not bound by that order to the extent that does not comply with the settled jurisprudence by the Supreme Court, which has been followed with approval, which has been followed in the Mwangaza case, by the Court of Appeal in the Mwangaza case, including decisions other cases, including decisions specifically in the Sonko matter, specifically also in the Wambora 2 matter, and also in the Wambora decisions are within the House. I yield the floor to my colleague. I yield the floor to my colleague. The issue of the threshold. The issue of the threshold. The number threshold. Thank you.
Mr. Speaker, sir, honorable members. Mr. Speaker, sir, for the record, my name is Hilary Kiplangat. For the record, my name is Hilary Kiplangat. I will address the third preliminary objection. Which is the question of whether, which is the question of threshold of the threshold required by Section 33, required by Section 33 of the County Governments Act. Was made in the impeachment. Was made in the impeachment. Honorable Eric of Governor Honorable Eric Mutahi. Mr. Speaker, sir, honorable members. Mr. Speaker, Section 33 of the evidence of the Section 33 of the evidence in the County Governments Act, the County Assembly to satisfy the County Assembly threshold of 2/3 a threshold of members to pass of its motion for the impeachment of the governor. For the impeachment. The controversy in this case, honorable Speaker, controversy in this case is that honorable Speaker, 31 members voted in support of the motion, voted in support of the motion in the humble submissions. In the humble submissions of the Speaker, as per this, they answered as per this of that day. They answered that constituted 2/3 of the members of the County Assembly. Of the members of the County Assembly. In his ruling, in his ruling, the Speaker of the County Assembly, the Speaker of the County Assembly, in page 131. Page volume 1 of our documents, of volume 1 of our documents, himself to be guided by a decision of the High Court, of Michael, and that is the case of Michael Gaduda versus the County Assembly of Tana River, versus the County Assembly of Tana River, and 4 others. KELRC 1605 in 1605. A judge of the High Court by the name Justice Manani, the High Court by the name Justice Manani, when it comes to matters rounding, when it comes to matters rounds off to the nearest whole number, the nearest whole number. Mr. Speaker, sir. So, Mr. Speaker, sir, it came to that determination. When it came to that determination, the County Assembly was guided by a constitutional position, by a constitutional position determined by the High Court, determined in that particular case which I have cited. In that particular case which I have cited. Mr. Speaker, sir, that position, that position, that is volume. That is volume 1 of our documents. Volume 1 of our documents. You will find the ruling of the Speaker. You will find the ruling of the Speaker in which he cited the case of Justin versus the County Assembly versus the County Assembly of Tana River. The decision of Justice Manani, the decision of is an application of elementary mathematical rule of rounding off, in which numbers are ordinarily rounded off to the nearest whole number. The same formula, has been applied in various other decisions, and a case in point is a case in point of Adrian Kamodo's Judicial Service Commission versus Judicial Service Commission, which interrogated the composition of the Supreme Court in compliance with the requirements that no more than two-thirds of the same gender shall be in that appointive position. And in that case, Honorable Speaker, the High Court, the Court of Appeal, and the Court of Appeal were very clear when it comes to rounding off, when you round off to the nearest whole number. The reigning jurisprudence, which handed down by our courts, rounds off to the nearest whole number. Rounds off to the nearest whole number. Honorable members, in this particular case, Mr. Speaker, honorable members, and Mr. Speaker, there are 47 members of the County Assembly of Kericho. To achieve two-thirds of 47, it will give you a number of 31.33. The nearest whole number, to 31 is 31, not 32. Is 31, in keeping with the jurisprudence which has been settled by our courts, which has been settled by our courts. Honorable members, and Mr. Speaker, honorable members, and Mr. Speaker, Assembly of Kericho, in County Assembly of Kericho, there are 30 electoral out of the 30 electoral wards, 29 men were elected as MCAs, and one woman was elected, and one woman was elected as a member of the County Assembly. In constituting the gender quotas for purposes of nomination, nominated an additional two men, making the number to be 31 men, 15 against nominated women. Nominated women. The number of nominated women in the County Assembly is 16. So is 16. So 31 men. 31 men of IBC. In the wisdom of IBC, it is important to note that IBC is a constitutionally mandated body that can ascertain gender quotas as per the law. Gender quotas as per the law. In their wisdom, and in their wisdom is 31, and that is why is 31. At the County Assembly of Kericho today, at the County Assembly of Kericho today, and we have 61 men, women, and 16 women MCAs. Even if we were to convert these figures, Honorable Speaker, percentages, you will realize that if we were to argue that 32 two-thirds was, it would yield a percentage of 68.05%. And in actual sense, would be a percentage of 66.67. So you will see that variance even if you convert those figures into percentages. Honorable members, Mr. Speaker, if one was to argue two-thirds is 32, and a third is 32, and a third 16 is, we would be having 16, a figure of 48 MCAs in the County Assembly of Kericho, which is not in the County Assembly of Kericho, which is not because we have that sense. We have position because we have that members of the County Assembly. Members of the County Assembly. This is a constitutional question which has been settled by the courts in Kenya, keeping with the doctrine of stare decisis, which provides bodies adjudicating on disputes which touches on the Constitution or the law are bound by the decision of the High Court. Or superior decision in the case of Gaduda versus the County Assembly of Tana River, as well as Adrian Jenga Kamodo, as well as Adrian Jenga Kamodo. Judicial Service Commission is binding in this House. Is binding in this House. It doesn't matter how many times how many times assemblies or the county assemblies or parliament has applied parliament at different formula. The only time when this matter has come up for determination is before the High Court, and the High Court is before the High Court, and the High Court has given that a finding. You round off that to the nearest whole number when you are confronted with an issue, when you are confronted with an issue, numbers to be rounded off. Numbers to be rounded off. Sir, those are our submissions. Mr. Speaker, sir, those are our submissions in respect of the third preliminary objection. Unless Mr. Bosek, which you can give him a minute or so. Which you can give him a minute or so.
Clerk, how much time? How much time is still available to the county assembly?
Yes, just to add a few, Mr. Speaker, sir, more points. Mr. Speaker, sir, that we've been supplied by Katwa Keegan. Learned friend Katwa Keegan certified, and also are not complete. I wish to also point out that when you look at what is purported to be the answered, what is purported to be the disclaimer that this electronic version of the official information purposes only. It's for information purposes only. A certified version can be obtained from the Hansard editor. Mr. Speaker, sir, honorable senators. Mr. Speaker, sir, honorable senators. We have not been with any document that shows that the same had been certified by the Hansard. In fact, we are not seeing we are not seeing from the Hansard any input, senator, from the Hansard senator. Having said that, we therefore stand to say that whatever that has been produced, from the Kericho County, just like the documents which were purported to have been produced, from the High Court in form of orders, from the High Court, did not go through the process of certification, and therefore probative value. And on that basis, we urge the honourable senators to look at them and to look at them, question, and to also question. Council will produce documents. Council will produce documents in themselves, self-defeating. I say no more. Thank you, Mr. Speaker, sir. I say no more. Thank you, Mr. Speaker, sir. Honourable senators.
Before I allow senators, before I allow senators to make the intervention, Council for Governor.
Thank you very much, Mr. Speaker, sir. The first, thank you very much, Mr. Speaker, sir. The first, I really just want to emphasize that for the governor, we place a lot of premium on the contention, that the two-thirds was not met. As a starting point in response to what my colleagues have said, Mr. Speaker, sir, it can be taken as an absolute fact that it was actually 31 people who voted, and that what was required was 31.3. What was required was 31.3. Leaves the question as we already posed. Leaves the question as we already posed. When you scale down to 31, when you scale down to 31, and as my learned friend Mr. Hilary said, you round off to the nearest number. Whether you still be meeting the requirements of Section 33, being at least. The second argument I wish to make in response to the argument is the question of the arguments whether this is a question of fact. Mr. Speaker, sir, honorable senators. Mr. Speaker, sir, honorable senators. It is a question of fact. They will call a witness to say this and this. They will call a witness to say this and this. But we are all in agreement. It is governed by Section 33 of Government. It is governed by Section 33 of Section 74. It's governed by Section 74 standing orders. The county assembly members is 47. The assembly members is 47. The requirements is 31.3. The requirements is 31.3. And not in contention. And no witness can change them. And no witness can change them one way or the other. Mr. Speaker, sir, honorable senators, Mr. Speaker, sir, honorable senators, for your determination. The issue is right. It is right for your determination as to whether you can scale down as to whether you can scale down 31.3. My colleague has also said that Mr. Boseka said that the Hansards we have relied on have not been certified. have not been certified. We wish to point out, Mr. Speaker, that the handsets on their face are for information purposes. And Mr. Speaker, sir, we are happy enough. And Mr. Speaker, sir, we are happy enough to rely on them to the extent to which it is of significance also that they do not deny. It is of significance also that they do not deny that those are accurate representation of what happened in the county assembly during the impeachment of the predecessor of Eric, and that is they do not contest that that was the criteria used to elect the speaker. Mr. Speaker, sir, Mr. Speaker, sir, then there is the contest about the question of the orders. Mr. Speaker, sir, the orders. Mr. Speaker, sir, this Senate very seriously. This Senate very seriously. And we cannot possibly have come with and we are really astounded. And we are really astounded of the magnitude and the standing of the county assembly could possibly say that the orders are a forgery. Now, the specific allegation that the orders were not served, Mr. Speaker, sir, Mr. Speaker, sir, 487 shows that page 487 shows were indeed served, and there's an affidavit of service. You will also see from the Hansard, you will also see from the Hansard brought by the county assembly, affidavit of service shows the service was effected between 9, 10 and 10 o'clock. And the voting for purposes of the impeachment was done at 2 as will be seen in the answer that was produced by the answer county assembly by the county assembly 58 at page if you go at page 50 sorry page 160 at page 161 it shows that they completed their process of impeachment at 218 so clearly service was effected long before they did the voting. Mr. Speaker, sir, we stand with the orders. Mr. Speaker, it is also significant that they say there was a forgery. It is also significant that my very good friend Mr. Hillary filed a notice of appointment to come into that case the day after, on the 3rd of October. If they are saying there were no orders, what were they doing getting there were no orders? What were they doing getting into that case? We want participating in that case saying represent the county assembly and challenge the orders obtained and challenge the orders obtained. Mr. Speaker, sir, we take exception. Mr. Speaker, sir, we take allegations made about the orders allegations made about the orders. Mr. Speaker, sir, with that, I would like to rest my response and request my indulgence for just 1 minute for my indulgence for just 1 minute for my learned friend Mr. Tunento just to say one thing. My learned friend Mr. Tunento just to say one thing, and we rest our case. Kindly, Mr. Speaker, sir.
Honorable Speaker, members of the House. For record purposes, my name is Tunde Manasseh. And I rise only to respond to one issue, Mr. Speaker. And that is the issue of two-thirds. And that is indicated by my learned colleague, Mr. Hillary. As indicated by my learned colleague, Mr. Hillary. The issue of two-thirds is not a mathematical question. It is indeed a legal question. It is indeed a legal question. For instance, Mr. Speaker, and if you take that, for instance, Mr. Speaker, 1.3, that a line over threshold has been drawn. A line over threshold has been drawn. And in mandatory terms, and the law states that in mandatory terms, at least 31.3. At least that means that you have to scale up. That means that you have to scale up to meet that threshold. The numbers, because if you reduce the numbers to 31, if you reduce the numbers to 31.1, that means that you've fallen below the threshold that is provided by law. Below the threshold that is provided by law. As you can, as you are aware, even in the standing orders of this House, even in the standing order 7 in the election of the Speaker, standing order 7 in the election of the Speaker, the House is composed of 67 senators. Is composed of 67 senators. Is a decimal point. Of that, Mr. Speaker, and as you can recall, Mr. Speaker, and as you can recall, the numbers were scaled up. The numbers were scaled up. This means that you do not reduce the number below what the law provides. The number below what the law provides. Or as the House debates on that. As you rule or as the House debates on that. Consider of a person, a point needs to be completed. You do not negate or remove that. You do not negate or remove that. So in our submission, person, we hold the position that the threshold was not met. Was not met. Mr. Speaker, and also one issue that Hillary raised, and it was containing the issue of the gender in the county assembly of Kericho. in the County Assembly of Kericho. The issue of gender in the County of Kericho is not the same in the County of Kericho under Section 33 of the County Government Act. Section 33 of the County Government Act. The House to look at what the law provides. To look at what the law provides. We can scale down to that. And we can scale down to that. Speaker, let it not be the House that sets the record, or give precedence the record that you can play with numbers. Let the House be very firm in its decision, be very firm in its decision, the rule of law. And that will be all, Honorable Speaker. That will be all, Honorable Speaker.
Thank you, Council. Thank you, the County Assembly and Council for the County Assembly. Now, I will allow senators to make intervention. Senators in this make intervention. Now, honourable senators, you will notice. Now, honourable senators, you will notice that this is not. This is the ordinary preliminary objection. The ordinary preliminary objection before been dealt with. It's a preliminary objection that is of a preliminary objection that is of a fundamental nature, or may not terminate. It may or may not terminate. Therefore, as you make your intervention, and therefore, as you make your intervention in mind, have that will in mind. Start with Senator Edwin Sifuna. Edwin Sifuna.
Honorable Speaker, allow me to put the question to council for the
Senator Mary. Certainly you cannot stand on a point. Certainly you cannot. I don't see anything disorderly. I don't see anything from Senator disorderly from the senator. From Senator. Just take a senator for now. Just take a seat. Unless you're seeking for any. Unless you're seeking for any intervention.
Honourable Speaker, of course, the honourable member for quite in order, but I was start seeking guidance, at the time. Maybe you can guidance at the time. Maybe you can guidance on the number of minutes senators, and also the minute, how many minutes can one the floor senator use on the floor, Mr. Speaker.
Honourable senators, if you strictly apply the then you have 2 minutes. Procedure, then you have 2 minutes. Proceed. Proceed. And 2 minutes it is.
I thank you, Honourable Speaker. My question goes to council for the. My question goes to council for the. And Honourable Speaker, I would like to. And Honourable Speaker, refer him to volume 1 of his. Refer him to volume 1 documents. At page 7, Honourable Speaker, at page 7, Honourable Speaker, 20, there is an averment there, Council, that has been made by the government that in fact, holding of the High Court, there was a holding of the High Court, Malindi, and this is ELRC petition number ELRC petition number. I don't know if we are together. I don't know if we are together. Page 7 of the bundle, at page 7 of the bundle, at paragraph 20. Council, volume number 1 of the governor's volume bundle. Number 1 of the page governor's 7. Bundle. For heaven's sake, Honourable Speaker. Page 7. For heaven's sake, Honourable Speaker. Wasted by things that have already wasted by
just
things
proceed.
That have Honourable Speaker, I'm referring to bundle. Honourable Speaker, I'm referring to the governor's bundle. Volume 1 of the governor's bundle. At page 7. Thank you, Honourable Speaker.
I tell you to repeat.
Thank you, Honourable Speaker. You have presented. You have presented paragraph 20, the averments at paragraph 20A as a holding of the court. A holding of the court. The paragraphs you have superimposed there. The paragraphs you have superimposed there. Now, you are a lawyer of great repute. You are a lawyer and reading a judgment you can ascertain. And reading a judgment you can ascertain. Finding of the court is what as a finding of the analysis of the as opposed to an analysis of the presentation of the parties. The judgment referred to is at the judgment referred to 70 is at page of that same bundle exhibit number 1 of that same bundle exhibit number 1. And I want the council and I want the governor to confirm to this house. The governor to confirm to this house that in fact the paragraph quoted at 20, the paragraph quoted is not a finding of the court on the question of is not a finding of the court on the question of means 2/3 and what should happen when there is a decimal and what should happen when there is a decimal. Honourable Speaker, will refer you. Honourable Speaker, will refer you quoted from paragraph 83, paragraphs he has quoted which cannot be a holding of the court, which cannot be a holding of the court, and in fact the holding at the paragraph 86 should be at paragraph 86 of that judgment. Of that judgment. Honourable Speaker, my question therefore to him is, Honourable Speaker, my question therefore to him is it proper for you to present an analysis of the case by the learned judge as a finding of the learned judge as a finding of the court? That is the question I wanted to put to him. Speaker, that is the question I wanted to put to him.
Senator Boni. Senator Boni.
Thank you, Mr. Speaker. Thank you, Mr. Speaker. My comment on this will be limited on what I begged the House, to help this country. Adopts to help this country. This is a very serious matter. This is a very serious matter. It is already on record. It is already on record. Can injunct no court, Parliament can injunct. So the first Parliament, so the first should collapse. A decision has already collapsed. A decision has already been made. My second comment, Mr. Speaker. My second is on the question, Mr. Speaker, numbers. Is on the question of numbers. Kanzo Mutuma. What would you like? What the would governor you like to prove? The governor to prove. This a scientific fact. This that 47 scientific fact that divided by 2/3. Divided by 2/3. 31 point is 31 point. As you guys say in law. As you guys say in law. It proves by itself. What do you want him by itself? What do you want? It is not possible for a human being. It is not possible for a human being, Mr. Speaker, to be a fraction. I want, Mr. Speaker, I want the Speaker that because you also have a responsibility to grow of impeachment. The philosophy. Let us agree. Impeachments. That let us agree. Let us give it to the governor. Let us give it to the governor. We give him the fact that a fraction of a human being does not exist. Of a human next time does not come exist. With full numbers. Next time and come with full numbers. To you. And we will listen to you. Finally, Mutuma, because you are very experienced in this process. Because you are very experienced in this process. The Speaker of the National Assembly said. Listen to what the Speaker of the National Assembly said about the same thing. The County Assembly of Nyamira said. The County Assembly of Nyamira said. About the same thing. The County Assembly of Kericho. The County Assembly of Kericho. During elections. About numbers. They have said the same thing. During elections. So why do you invite dividers? So why do you invite dividers? So as to disagree with all of them. Or to allow. So as to please you, the proper jurisprudence. The proper jurisprudence.
Senator Ledama. Senator Ledama.
Thank you, Mr. Speaker. Mr. Speaker, I just want some clarity. Mr. Speaker, I just want some clarity of the governor. The council of the governor. The council for the assembly. The council for the assembly has presented facts. Had already been determined by a court. Had already been determined by a court. In their volume 1, page 131. Volume 1, page 131. There's a finding of the court. There's a finding of the court. When it comes to the issue, it is not 2/3 an issue where it is not you determine an issue where you determine the question of a human being the question of a human being but rather able to be fractioned, but rather are you then in your submission? Are you then question in your submission, or rather question you challenge, or rather have you anyone else challenge, or has anyone else challenge of the court that finding in the matter of Michael in the matter of Justin Dunda? With the County Assembly, Justin Dunda of the County Assembly, Tana River. So that is a point that I'd like you to clarify. So that is a point that I'd like you to clarify of the court. Because this is a finding. Number 2 on that issue. Number 2 on that issue. Finding on the matter to deal with on the finding on the matter where the court, where the court, the facts presented by the Assembly, the facts stated that by the Assembly, stated that you round off number. To the what would be the nearest whole number? What would be the nearest whole number in a matter which is 31, or is it 31, 32. Or is Thank it you, Mr. Speaker. 32? Thank you, Mr. Speaker.
Senator Samson Chirenge. Senator Samson Chirenge.
Mr. Speaker, you need to protect me from the majority. Mr. Speaker, you need to protect me
Mr. Speaker,
just
I want to agree with my
Mr. Speaker,
just
I want to agree with my colleagues
that
in the history of this parliament, no one can injunct parliament. That aspect of injunction of parliament, or court order before the parliament or the Senate, or court order before the parliament or the Senate, and therefore I think I think the governor to stop pursuing that line of the governor. Number two, and finally, Mr. Speaker, on the Mr. Speaker, my concern is on Section 33 of the County Governments Act, 181 on removal of 181 on removal of Speaker, and in the decision of Raila Odinga versus IEBC, the Supreme Court pronounced itself that when the process has taken off, when the process has taken off, and it is time bound, in that ruling, that process is time bound. So by the fact that you read the charges, and the process is ongoing, when you look at the process number 16, when you look at rule number 14 and rule number 30 on rule number 14 and rule number 30 on the removal of a governor, the process is already ongoing, and the process is already ongoing. And so, Mr. Speaker, the question should be, the process has already begun. If the process has already begun, 33, as per Section 33 of Article 181 with the genesis of Article 181, therefore, what happens, Mr. Speaker? I agree that in scientific proof, I agree that you cannot have a fraction, but you cannot have a fraction, but also for some of us who are not very good in mathematics. So, Mr. Speaker, you must balance both. So, Mr. Speaker, you must balance both. We give justice to the county assembly, we give justice to the governor, and any other person, including the people, and any other person, including the people. So since the train has left the station, let us go ahead and listen to the merits and demerits of the case. Then we determine. I submit, Mr. Speaker.
Senator Kajwang.
Mr. Speaker, the issue of limits on independent institutions has been settled, and I think we have seen some precedents that have been presented to us. Secondly, we need to make a distinction. We need to make procedural fairness between procedural technicality and procedural technicality. Procedural fairness demands that the governor for Kericho has been accused and all sorts of allegations have been made against him. This is opportunity to defend himself against those allegations. There should be procedural fairness. There should be procedural fairness in our constitution, as required. The other aspect is procedural technicality. The other aspect is procedural technicality. That if we were to be obsessed with in 1992 it is John Harun Mwau. In 1992 it is John Harun Mwau because he went to court and said he's the only one who presented. Because he went to court and said he's the only one who presented rather than on an petition in a full scap, rather than on an A4 paper. The ruling that has been referred to, we are getting by both different interpretations. We are getting on this matter. We should not go on this matter. We should not go Rule 30 empowers the Speaker to make a decision. Rule 30 empowers the Speaker to make a decision. The way we did in the case of Nairobi, there were affidavits that were sworn by MCAs. There were affidavits that discredited the outcome of the vote. That discredited the outcome of the vote. That let's allow all parties to prosecute. That let's allow all parties to prosecute. And then the senator sitting as a jury. And then the senator sitting as a jury would make a decision. I would propose and I would urge, Mr. Speaker, I would propose and I would urge Rule number 30, but allow the House to Rule number 30, but allow the House that there is procedural and ensure that there is procedural fairness in the matter of Kericho.
Senator Kathuri. Senator Kathuri.
Thank you, Honourable Speaker, for this chance. Thank you, Honourable Speaker, for this chance. Of the 2 minutes also to make a very important. This very, Mr. Speaker, as we are here, many Kenyans are Mr. Speaker, as we are here, many Kenyans are watching TVs because you know their TVs. Many Kenyans are now sensitive on many Kenyans are now sensitive governance, sensitive on so, Mr. Speaker, the PO number 1. So, Mr. Speaker, the PO number 1 is actually so the PO number 2, Mr. Speaker. So the PO number 2, Mr. Speaker, besides because the High Court pronounced itself that you go to the High Court pronounced itself that you go to the nearest zone number, you run at that. When you go to the nearest zone number, you run at that. The argument is about now. The argument is about now the Kericho that has been put in Kericho County when they were electing the county, the speaker. So, Mr. Speaker, because this matter is about mathematics. So what I would request us also other colleagues we would like to hear these cases. We would like to hear the Kericho County Assembly. We give the Kericho County Assembly time and the Kericho County Governor to their matter before this to prosecute their matter before this. Because if we determine this matter in any other way, rather than listening to the party justice to the then will not be giving justice to the country at large, Mr. Speaker. So Senate country at a house that cannot be able to protect that cannot be able to protect the mission. I wish that we are able, and then we are judges, and then this is a High Court sitting, Mr. Speaker. This is a High Court sitting, Mr. Speaker. We will be able to make our determination in one or the other, Mr. Speaker. Thank you.
Senator Wambua. Senator Wambua.
I thank you, the Speaker. I thank you, the Speaker. Two things. One. I don't know why Senator Alwale would want to pick and choose. Senator Alwale would want to pick and choose. A precedent has been set. A precedent has been set in the court, and he has quoted it. In the court, and he has quoted it. Suppression of powers. The matter of suppression of powers. No court can injunct. That no court Parliament can injunct in its prerogative roles. And so PO number one, everybody agrees. And so PO number one, everybody falls on its face. It falls on its face. The Speaker, then Speaker number two. Then PO number two. You know what the lawyers on both sides are asking. What the lawyers on both sides are asking these judges here is a very complicated matter. It's a very complicated. It's a matter of determining. It's a matter of determining a human being. A fraction of a human being. What is 0.3 of a human being? What is 0.3 of a human being? What is it? Is the head?
As a Speaker, again, the courts are pronounced themselves. As a Speaker, again, the courts are pronounced themselves on that.
In the case of Tana River, in the case of Tana River, in a matter like this, to the nearest, then you round off to the nearest, which is all number 31. As a Speaker, there are 31. As a Speaker, there are matters for determination in this motion. In this motion, that this House needs to be that this House needs to be, and you ask me, Mr. Speaker, and you ask me, Mr. Speaker, said as Senator Legea said, left the station. The train has already. We are already in motion. We are already in motion. This case, let's make this case. Let's one way or the other. Speaker, I submit. One way or the other. The Speaker, I submit.
Senator Chariot.
Thank you, Mr. Speaker. Mr. Speaker, the people of Kericho have quarreled. Mr. Speaker, the people of Kericho have quarreled to seek for justice. And we've come before this House to seek for justice, less than justice. And we pray for nothing in the interest of the people of Kericho. I want to make two quick observations, Mr. Speaker. One is unanimous by what colleagues have said. Is unanimous that PO number one has been determined not only by Parliament itself, by not only by Parliament itself, the Supreme Court of the Republic of Kenya, none other than the Supreme Court of the Republic of Kenya, Mr. Speaker. In Wambora 1, 2015, Mr. Speaker. It has been firmly established on what you do with a parliamentary process, either in Parliament or at the county assembly, once an exercise has commenced. Therefore, on that count, Mr. Speaker, I plead that the Council for Governor appreciates that particular issue. Second and most important, Mr. Speaker, Mr. Speaker, is on this I wish my good friend Senator Boni Halwale. Mr. Speaker, there is what you call the hierarchy. Mr. Speaker, there is what you call the hierarchy. The Constitution reigns supreme. The Constitution reigns at the top, supreme. And when a matter is not sufficiently addressed in the Constitution, you look for it in statute. You look for it in statute. Where there is none, Mr. Speaker, where there is none, Mr. Speaker, what follows is after that already established. Already established. Mr. Speaker, the Speaker of the County Assembly, the Speaker of the in his affidavit, and it is affidavit Volume 8
it
of
is
the
hereby presented
documents
in
from the
Volume
Assembly,
8 of the
cited documents from the Assembly,
court decisions that have been
cited
made on this particular
court
issue.
decisions that have been
Therefore,
made on
Mr.
this
Speaker,
particular
I don't know
issue.
on what basis
Therefore, Mr. Speaker,
you would want
I don't
to
know on
fault
what basis
the Assembly
you would want to fault
because I have
the
listened to
Assembly,
Counsel for Governor
because I have listened to Counsel for Governor, and there is no citation
other than
whatsoever
on their part other than
this theory
application of
that
mathematics.
we want to be told
this
that
theory
there is no half
that we
or
want to
quarter
be
of a
told
human
that
being.
there is no
I
half
thought,
or
Mr.
quarter
Speaker,
of a human
that
being.
being a
I
house
thought,
of
Mr. Speaker,
procedure,
that being a house
we
of
would
procedure,
establish
what
we would
is a
establish
practice that has been established
what
in our courts
is
of
a
law.
practice that has
Mr.
been
Speaker,
established
you
in our
know,
courts of law.
Mr.
What I
Speaker,
find
you
to
know,
be extremely curious,
what I find to
though,
be
is a very
curious,
dangerous
though,
invitation
is a very
that the
dangerous
Council for Governor is
invitation
sending out to you.
that the Council for
I
Governor is
listened
sending
to
out to
him,
you.
Mr. Speaker.
I listened
and
to
he
him,
wants to
Mr.
lead you
Speaker,
to make a decision
and he wants
that
to
has
lead
never
you to
been
make
made
a decision
by
that
any
has
other
never
speaker
been
in this
made
House, Mr.
by
Speaker.
any other speaker
Where he
in this
wants
House,
you
Mr.
to make a
Speaker.
determination
Where he wants
on
you to
appeal
make a determination
and dismiss this
on
case
appeal
altogether.
and dismiss this case altogether.
Now, have a seat. Have a seat, senators.
It is now
Honourable senators, it is now 4 minutes. We can only, during a morning session, prosecute business up to 1 and therefore allow me to invoke standing order 34 to extend the time for 15 minutes. The time for 15 minutes. We shall thereafter rise. We shall for a break. Rise. We'll come back at 2:30. We'll come back at 2:30 because it is of such a fundamental nature. I'll give you 1 minute to conclude. I'll give you 1 minute to conclude.
Mr. Speaker, you are being invited to
Mr. Speaker, you are being invited
previously
to very
before this
dangerous
house,
path.
in Mike Sonko
Previously
versus
before
County
this
Assembly
house,
of Nairobi,
in Mike Sonko versus
and
County Assembly of Nairobi,
previously also in
and,
Ferdinand Waititu versus
previously
the County
also in
Assembly of
Ferdinand
Kiambu.
Waititu versus
Such
the County
POs have been
Assembly of
raised.
Kiambu.
What did
Such
your
POs have been
predecessors
raised.
do?
What did
They
let
let
your
the
predecessors
jury make
do?
the determination.
They let
which
the
is
jury
all the
make the
47
determination.
delegations.
Do
all
not
the
accept,
47
Mr. Speaker,
delegations.
the
Do not
invitation that
accept,
is being
Mr.
passed
Speaker,
on to you,
the invitation
that
that
is
is
being
being
passed
passed
on
on
to
your
you,
own,
to make
the
a determination
Constitution,
on
nor
your
our
own.
standing
The
orders,
Constitution,
or legislation,
nor our standing
never
orders,
envisioned
or
a
legislation
situation where the
never
Speaker
envisioned
will
a
terminate
situation where the
proceedings
Speaker
such
could
as this,
terminate
Mr. Speaker,
proceedings purely
such as
on
this,
a point
Mr.
of
Speaker.
order. Therefore, I want to
Purely
humbly
on a point of
request
order.
you, Mr.
Therefore, I want
Speaker,
to humbly
that just as we do in
request you, Mr.
legislation,
Speaker,
that
let
just
us
as
make
we
a
do in
determination on
legislation,
this PO.
let
If
us
it
make
comes
a
to
determination
voting,
on this
let it
PO.
be the
If
case,
it comes
Mr.
to
Speaker.
voting,
But
let it be
on
the
your
case,
own
Mr. Speaker.
motion, Mr.
But
Speaker,
on your
in
own
the interest of
motion,
justice
Mr.
for the
Speaker,
people of Kericho,
in the interest of
allow us
justice
to
for the
listen
people of Kericho,
to this case
allow
and
us to
eventually
listen
make a
to this case
determination
and
one
eventually
way or the
make a
other. I
determination
thank you.
one way or the other.
Senator
I
Mogeni.
thank you.
Senator Mogeni.
Thank you, Mr. Speaker. Mr. Speaker, thank you, Mr. Speaker. Mr. Speaker, what I had my classmate, Kegan is to invite you to invoke, standing order number 30, standing order number final determination, to make a final determination.
It is a rules of procedure, not standing. It is a rules of
Okay,
procedure,
yeah.
not standing.
Under, I think the third schedule. Under the rules of the third schedule. Mr. Speaker, my understanding is, Mr. Speaker, my understanding is, an impeachment, the moment an impeachment on the floor of the Senate, it becomes the property. It becomes the property the jury of the jury. Who are the senators? Who are the senators? These proceedings were being conducted by a special committee of 11 members. By a special committee of 11 members. You will never be invited. You will never be invited to make a determination whether a two-thirds on the issue of whether that decision will be made by that committee by that by extension also, Mr. Speaker. By extension also, Mr. Speaker. The right people, the right people, the right person or person to make a determination as to whether the threshold reached during impeachment. And I agree with those who have spoken before. And I agree with those who have spoken before, Mr. Speaker, that precedent during the Sonko hearing, Mr. Speaker, similar matters arose before us. On issues of quorum. But the Speaker ruled the Speaker then those issues be argued as part of the defense. And then the senators make the senators determination. I invite you to be extremely. I invite you.
There is a question of the governor. There is a question of the governor.
on the basis of just the argument of the threshold, determine that there is no case to be had by this Senate. There is no case to be had by this Senate. It is important that Senate sitting as a jury, Senate sitting as a judicial setting, and to make that decision themselves. To make that decision so that themselves. It also becomes so other precedent cases becomes other various as mentioned by various mine in the house of cases mine in the house appearing of cases before the same Senate appearing before the same Senate. Can you allow this Senate to make that decision? Senate to make that decision so that it becomes by way of voting another precedent becomes also setting another precedent rule rather than taking the burden of making a decision, taking the burden of making a decision that are expecting the people of Kericho are expecting, the issue before the Senate, the issue really before the Senate and adjudicated of
sentiments by previous speakers, by previous wish to point out, very important issue when comes very important issue the PO on the threshold. The PO on the threshold. Mr. Speaker, I want to point out that when the threshold has been about gender, the math to surround it, to round it, to round off the figure has sufficed. An example to demonstrate this is the very county assembly of Kericho. So I wish to call upon our colleagues. that to take note